Will today be the day that the Supreme Court takes on another Second Amendment case? They certainly have enough cases being petitioned in front of them. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, we are back on the Supreme Court watch list. We've got plenty of cases involving a lot of different challenges that are going to be taken or cast aside by the Supreme Court. We're watching it again today, but to talk us through it, we've brought back on the volunteer president of CRPA, that is Chuck Michel. Chuck, thanks for being with us today.
Always a pleasure. Thanks for having me, guys.
Absolutely. And before we get into it today, guys, please be sure to like, share, and subscribe to this channel. Really helps with the algorithms to get this information out to as many people as possible. We're making a really big push in advocacy, and we're coming up to the 2024 general elections. We want people to be as informed on two-way litigation and legislation as they go to those ballot boxes as they possibly can be. So, Chuck, let's just get right into it today. We thought that today could be a day where we see the Supreme Court take up another Second Amendment case. Doesn't really turn out to be that way. The only thing that I saw was the Bianchi challenge out of Maryland that was challenging an assault weapons ban law got denied. Can you just sort of wrap this up? First of all, you know, we're saying that we're watching the Supreme Court to see if they'll take up a case. What is this process in general of the Supreme Court taking up a 2A case?
Sure. Okay. So the Supreme Court holds internal conferences amongst the 9 justices where they go through the list of cases that are pending, have a pending request to be reviewed by the Supreme Court. It's called a petition for certiorari. And then they decide which of those cases is going to deny the petition for cert, grant the petition for cert, or take some other action. And it takes 4 of the 9 justices to take a case. And then obviously it takes 5 of the 9 justices to win a case. So there's some internal dynamics going on. For years, before Heller came down, we tried to get Second Amendment cases in front of the Supreme Court, and they didn't take it because although we had 4 votes, we weren't sure we had 5. So our friends were voting not to take the cases because they didn't think we could win them. That changed, that actually kind of went back to that again after Heller and McDonald because of Justice Kennedy. We weren't sure we had that 5th vote to win. So no cases were accepted at one of those conferences, Supreme Court conferences, until the Bruen case was accepted. And that's after there were some changes on the Supreme Court where we had more judges in our favor. So we win Bruen, and now the courts are doing, the lower courts are doing the same, playing the same games that they played after Heller, twisting the Supreme Court's words, twisting the holding by the Supreme Court to make it easier to uphold gun laws that should be declared unconstitutional. And a number of cases have asked the Supreme Court to take their case, some after judgment, some on what's called interlocutory appeal after a preliminary injunction, and some before judgment where there wasn't a lower court decision yet. And the least likely cases to be accepted are those where there's still a lot of work to be done in the lower court. And the most likely are ones that have been litigated through final judgment. And then in between there's the interlocutory appeals, the preliminary injunction or permanent injunction requests that are either granted or denied, but there hasn't been a judgment issued yet. There's just an injunction. So the process is they file the lawsuit, you seek a preliminary, typically in a Second Amendment case, we seek a preliminary injunction, we get a ruling on that, that can be appealed. And then if it's not appealed, you move towards permanent injunction and judgment. So the court met last Thursday to decide whether or not to take several Second Amendment cases. There are, I think, 3 or 4 out of Illinois. There was 1 out of Massachusetts, that's the Bianchi case. And I think the Antona case, which is the sensitive places case where they're trying to designate most of New York to be a sensitive place, is being considered by the Supreme Court too. So that the results of that hearing that took place on Thursday came out this morning on the Supreme Court's website, and the Supreme Court denied the petition for cert before judgment in Bianchi. So Bianchi goes back down to the en banc panel to be fully litigated, and maybe back down to the trial court. But that case is not going to the Supreme Court right away. It can definitely come back. The Illinois cases have been what's called relisted. So they're going to be discussed further this Thursday in the Supreme Court, again, by the internal conference among the 9 justices. And those justices will then decide what to do with that case. They could so on Monday, we'll be doing this. Next Monday, we'll be doing this again to see what the court did with those Illinois cases. Now, again, they could grant cert, they could hold the case, they could deny cert, they could even conceivably accept the case for review and short circuit the whole process and just give the lower court some guidance and send it back down to them. They may wait. They may be waiting for the Rahimi case to come down in June, and then they might do what they did after Bruin, which was grant a bunch of cases, vacate the lower court ruling saying that the laws were constitutional, and then remand the case, send the case back down to the lower court and say, reconsider your ruling now in light of, in those historical cases, in light of the Bruin decision. Perhaps, depending on how much guidance we get out of the Rahimi decision, they could do the same thing with these Illinois cases, or they could accept them for review. So we're going to have this conversation next Monday and see what they did with the Illinois cases and talk about what it means.
So you're saying that they can grant them, they can hold them, or they can remand them. Seems like they're holding them now. If they continue, I guess the question that I have for you is, are there any limits to this? Are we having this conversation every Monday from now until forever if they decide to hold it?
It might be realistic if it's relisted once, if it's carried over from one conference to over 1 week, that's not necessarily a bad sign. That means that they're trying to learn more about the cases, or they're just doing some homework. If it's relisted several times, that typically means that they're not going to grant cert, but some of the justices want to write a dissenting opinion saying that they should have granted cert. So if it gets relisted again this week and next Monday there's still no answer on the Illinois cases, that's probably means we're not going to get cert, but there will be some judges issuing dissenting opinions saying we should have granted the case and heard it.
Gotcha. So we mentioned these things singularly in videos from time to time. I guess this is an opportunity to wrap them all up, in one video. What exactly are we seeing as far as the challenges to the Supreme Court that are currently being held? And as far as those challenges are concerned, are we more so looking for the individual decisions on what the cases are? Or, like you've stated in a past video, are we more so looking for clarification on how to actually view Second Amendment cases that, can be taken from Bruin?
Well, I mean, it's a bit of both. See, that's the thing about Rahimi. It could clarify the methodology which would apply whether it's a semi-auto case or a magazine capacity case or a prohibited persons case or a prohibited places case. The methodology applies to all Second Amendment cases, no matter what the hardware or restriction is. So obviously, we want a case that specifically says that semi-automatics cannot be banned and that magazines over 10 rounds cannot be banned. But if we get out of Rahimi a case that says, here's how you apply this, you look at the language of the Second Amendment, if the conduct is covered by it or the hardware is covered by it, and certainly magazines and semi-autos, and for that matter, full autos are covered, they're all bearable arms, then the burden shifts to the state, and the state has to prove that there's a historical tradition that would allow this kind of regulation because there was this kind of regulation in the past. That test, which should be pretty simple, that test is being distorted. It was totally turned on its head in the Seventh Circuit, the Illinois cases, and it's been totally ripped up in several cases in the Ninth Circuit, although some panels of the Ninth Circuit are getting it right. There's internal dynamics in the Ninth Circuit that's very interesting amongst the judges in the Ninth Circuit. But so we don't necessarily need a case that says from the Supreme Court that says you can't ban semi-automatics. if we get a case that says, here's how you lower courts should be deciding whether or not a state can ban semi-automatics, and you're not doing it the right way, so do it the right way. Both could be a win.
Gotcha. So it's actually almost like instant versus long-term gratification. You could get a decision saying this specific thing is unconstitutional, which could allow you to challenge existing laws in California. But you could also get this is the process by which you get there, which can help with basically
With
unlimited
every
cases.
case.
Right.
Because they're
Which
twisting that methodology. They're twisting the Supreme Court's test to make it so more gun control laws can be upheld because some of the justices are biased.
which makes sense. So, as far as the outlook on this is concerned, you say a case. Realistically, does the Supreme Court look for which case can best exemplify that process? I guess this is in your opinion.
They're looking for the best case that has the most the record that they need to, the factual development and the record, the legal arguments that were made to for them to they pick the cases based on how well developed it is and also what lawyers are on it. So, one of the lawyers that the Supreme Court knows very well is Paul Clement, and he's one of the lawyers that's on the Barnett case out of Illinois. So they might choose that case because they know and respect Paul Clement to argue it. I mean, all those factors go into the Supreme Court's decision.
Does that mean, though, in your opinion, if there's a dozen 2A cases petitioning to the Supreme Court, they just take one and deny all the others because that one, or do you maybe think there's an opportunity for multiple cases that are currently waiting?
Well, I think
get
that
accepted?
the Illinois cases are all semi-auto cases, and they all challenge the same law. So it's likely they'll just take one, and then the others will participate as amicus. Now they'll hold the others. They don't necessarily deny certain the others. They just hold those until the one case is litigated, because they're kind of redundant. But then again, on the other hand, like the Antonic case, that's a different issue. That's sensitive places and where CCWs are valid. So they wouldn't necessarily just take a semi-auto case and say that's good enough for the sensitive places case. They might take both. But again, if they take a semi-auto case and clarify the methodology and lock that in, that would then apply in the sensitive places case as well and could mean the difference between winning and losing that sensitive places case.
And then I guess the process is revitalized if they do offer, a clarification on the way that you apply the Bruin decision, allows organizations like CRPA to inform local legislators and law enforcement and judges on how this is supposed to be. And we can continue challenging the gun laws that are currently here. Chuck, I guess, what are your final thoughts on this Monday versus next Monday versus the immediate outlook of the Supreme Court possibly taking a case?
Well, I think they know they have to take a case. I just hope they take it sooner rather than later. And I think they know the clock is ticking, because they went through this after Heller. This basically it's judicial disobedience. They're thumbing many lower courts, particularly some of the judges in the Seventh Circuit and the Ninth Circuit. They're thumbing their nose at the Supreme Court, saying we don't like what you said. We're not going to follow it. And we're going to find ways to sneak around it, to twist what you said so it comes out the way we want it to. And the Supreme Court, they realize that they have a legitimacy issue going on here, their own credibility, their own authority. I mean, the lower courts are not showing the Supreme Court the respect that it's supposed to get. So hopefully those judges on the Supreme Court will demand that respect by issuing an opinion that clarifies things and says, hey, do what we say. We're the Supreme Court. You're an inferior court.
Right. Well, absolutely something that we're going to continue and pay attention to. Chuck, hopefully soon we can have you back on to discuss the case that they take and how it's going to, positively affect the advocacy here in California. I want to thank you for coming on. I know you're a busy guy. Looking forward to the next one.
Me too.
Absolutely. Well, thanks. And guys, if you like videos and content like this and you want to stay updated on Second Amendment litigation in California as well as in the Supreme Court, please be sure to like, share, and subscribe to this channel. Hit that notification bell so that you get notified as these videos come out so that you can be as up to date as possible. Thanks again, guys, and we'll see you on the next one.